Free audio post-production by alphonic.com.
Hi everyone, welcome to School Slow again with Salamatu. And today's discussion is going to be centered on an introduction to some courses you would likely study, if not in your first, in your second or third year in law. The discussion specifically focuses on commercial law, administrative law, and criminal law. So we are just going to talk about what each course is about, what kind of books you can use or materials you can use, seminal cases you should read before the start of the semester. So let's start with commercial law. Now, you would have done immovable property law, which is land law, before you do commercial law. So with your knowledge in immovable property law, which is land law, I need you to understand that commercial law is also simply property law, except that it governs a different category of property, which we call personal property or movable property. Okay. So immovable property basically has to do with land and all the things on land. Movable property, on the other hand, has to do with property that can, as the name suggests, be moved from one place to another. So you know that land is indestructible, is immovable and all that. But then movable property, what in English law is known as personal property, can be moved from one place to another. It can be destroyed and all of that. And commercial law deals with the law regulating interest in personal property or chattels. And as you may have guessed, the transfer of interests in movable property occurs by way of trade. And so broadly or by extension, we would say that commercial law is that part of law or is a set of laws that provide rules for trade or rules for business or commerce. As a result, in commercial law, we are concerned with issues like the transfer of property. When does property pass? Transfer of title, when does title pass, a sale of goods, and all the issues that arise ancillary to the sale of goods. So, who is the seller? What are the obligations of the seller? Who is the buyer? What are the obligations of the buyer? Commercial law provides rules for all of these areas. The distinction between immovable property law and movable property law, which, like I said, is just commercial law, is important because even the type of remedies that are available for an interference with either of them is different. When it comes to immovable property law, which is land law, where there has been an interference with an interest in land or an interest in immovable property, the most common remedy at common law was a recovery of possession, because one of the characteristics of land was that it was indestructible. So hardly will the interference with any person's interest cause a distraction to the subject matter of which is the land. On the other hand, movable property can be destroyed. And so most of the time, the remedy that comes close to doing justice would be damages. Because if the subject matter, which is, let's say, jewelry or a car, has been destroyed as a result of the interference, then the best remedy available is the remedy of damages. An important case you should read before the start of the semester should be the case of Kum v. Watat Bank, a case in 1971, where Lord Devlin stated the function of commercial law in society. He stated that the function of commercial law is to allow, so far as it can, commercial men to do business in the way they want to do it and not to require them to stick to forms they may think outmoded. This simply means that commercial law is there to facilitate business transactions. It is there to ensure that businesses run smoothly. And so it is not meant to be bureaucratic or it is not meant to be static. It has to evolve to meet the changing business times and to suit the current business climate. Historically, modern commercial law has roots in what we call the Lex Mercatoria, which is the law merchants, which was an international law of commerce which applied across Europe. Now, English merchants used to travel to sell their wares all over Europe. And anytime they embarked on these trips to sell their merchandise, they came into contact with disputes here and there. Now, in resolving these disputes, they would usually submit these disputes to specialized courts. It was flexible enough to adapt to new mercantile practices and was applied very speedily, or its administration was very speedy compared to the common law. So as time goes on, a lot of these merchant courts, the special courts I talked about that deal with mercantile disputes, would collapse or would become defunct. And so most of the mercantile litigation would end up going to the common law courts. And in an attempt to keep this business, in an attempt to continue attracting these mercantile disputes, the common law would adopt some of the Lex Mercatoria. By the late 17th and 18th centuries, the Lex Mercatoria would come to have been fully incorporated into the common law. Some important texts and materials you can use. So you can use Seeley and Hooley, a book titled Commercial Law, Text, Cases, and Materials. It contains a lot of the historical background. For local textbooks, I personally used Akapame and Alija 2021. They call it Commercial Law in Ghana, a source book. We talked about commercial law. Let's talk about administrative law. What is it about? What should you look out for? What are the texts and materials you can use in the course of your studies? Now, you have done constitutional law, okay? So your knowledge of administrative law is going to rest on how strong your knowledge of constitutional law is. Administrative law is that part of public law, or if you like, constitutional law, that regulates specific organs of states. Now, constitutional law would establish these organs of states and it will give them specific powers. The entire concept of constitutionalism is that there should not only be organs of states, but then there should be some sort of restrictions on these organs of states. The specifics of those restrictions is what administrative law is about. I was hesitant in saying that administrative law is that part of constitutional law because not all administrative law would be found in the Constitution, even if the Constitution has sanctioned it. So, for example, some administrative law can be found in legislation. And you know that legislation is a source of law because the Constitution says so. So, indirectly, whatever rules on administrative law that any specific legislation provides would have been sanctioned by the Constitution because the Constitution recognizes legislation as a source of law. But it doesn't necessarily mean that those rules are found in the Constitution. Stanley D. Smith defines administrative law as the general principles of law which govern the exercise of powers and duties by public authorities. And so, as I mentioned, administrative law is concerned about specific rules, which will serve as some sort of restriction on specific authorities of states. The entire concept is based on the assumption that once people have power, they are likely to misuse that power, or there's a possibility that they will misuse that power. And so there has to be restrictions. And so constitutional law deals with the establishment of these state structures. Administrative law deals with the specific rules that provide the restrictions. And so in administrative law, you'd be concerned with, first of all, the overlap between administrative law and constitutional law. You would also look at concepts like judicial review. You would look at prerogative writs, very important because historically we have learned, even in constitutional law, that prerogative writs are used to enforce some of these restrictions. So we are talking about habeas corpus, we are talking about prohibitions, quo warranto, and all of that. You'd also be concerned with delegated legislation, among a host of other topics that would require you to assess these restrictions. For text and material, I would recommend Erwin and Bradley on constitutional law and administrative law. It's a book that talks about both constitutional law and administrative law, which you would find helpful. It really did help me. The last course we'll look at is criminal law. And as the name suggests, criminal law is just going to talk about what the laws of crime are in the country and the concepts that are related to it. However, in your first semester doing criminal law, you wouldn't go straight into talking about the specific offenses. There's a lot of background that you should have learnt about before you start dealing with the specific offenses. So you would look at punishments, you would look at the two elements of criminal liability, which is the actus reus and the mens rea. So in your early weeks of doing criminal law, you should expect to talk a lot about the actus reus and the mens rea, which constitutes a broad part of your discussions in the very first few weeks of doing criminal law. The physical element, which is the actus reus, is simply the prohibited acts or the physical act which has been prohibited. Then we have the mens rea, which is the state of mind. Usually we would say the intent, but then intent is just one out of the many possible states of mind required or necessary to establish criminal liability. And it may not necessarily be the important elements that we are looking for in determining criminal liability. If the offense creating provision under the law says that the required state of mind or the prohibited state of mind is knowledge, then intention does not matter. So intention is just one of the many possible states of mind that are needed to establish criminal liability. And in the very first few weeks, these are the things you'll be talking about. You'll be talking about the actus reus, which is the physical element. And you'll also be talking about the different categories of states of mind that are required and how they influence liability. You'd also look at the concept of causation, because just like in negligence in torts law, where it is necessary for the negligent conduct to be the cause of the resultant injury, it is also important in criminal law or in establishing criminal liability that the physical elements of the crime, of course, together with its associated states of mind, be the cause of whatever injury that has resulted in the charge that we are discussing or we are talking about. So causation is also a very important concept. And so you spend a lot of time also talking about it. And you do this side by side with the Criminal Code Act 29. So issues like the use of involuntary agents. So if somebody commits a criminal offense and he did that by using an involuntary agent, let's say a child who is 11 years old. So under law, children who are below the age of 12 are under the age of criminal liability, so they cannot be criminally liable. So if somebody who has reached the age of criminal liability uses an 11-year-old child to commit a criminal offense, would the chain of causation have been broken so that this principal cannot be liable for the resultant conduct? These are the issues you talk about in causation. And so, yes, criminal law right from the beginning is about talking about crime and the specific conducts that have been prohibited. But even before you go and talk about those specific offenses, the curriculum is structured in such a way that you would talk about actus reus, mens rea, causation, and even defenses, because sometimes defenses have a way of influencing criminal liability, because if the person has a defense that is recognized in law, let's say intoxication or lunacy or anything like that, then they can be criminally liable. So you spend more time in your first semester talking about all of this before you then move on to the specific offenses, maybe in the latter part of the semester or in another semester altogether. I'll recommend in criminal law, I would recommend My Lady Mensah Bonsu's The General Part of Criminal Law, both volumes 1 and 2, which I personally used. I'll also recommend her Annotated Criminal Law, where she takes each and every section of the criminal code and then she gives you specific cases under them. It is particularly helpful when you start discussing the specific offenses, because in an exam situation, you would not only have to state the specific provision that has been violated, but you would also have to go ahead and state cases behind them in order for you to be able to have a wholesome discussion. One thing I would like to add when it comes to criminal law is that you must always be ready to read the cases that have been given, because the law is contained in the cases. The criminal code would tell you what is a crime, but then the discussion of what that really means in real life would be given to you in case law. So if there is any reference to any case in any textbook you're using, you have to ensure that you read it for better understanding. This is where we end today's video. I hope that this helps in preparing for these courses that I have mentioned. You also have to understand that one very important thing in law is that you have to listen to your lecturer, because the lecturer is the one going to set the questions and he's the one going to mark your answers. So you have to listen to the lecturer. You have to ensure that you read cases that they refer you to. You have to buy the text materials that they ask you to buy. And you'd also have to read the articles that they ask you to read. And I think that together with the tips I've given you or the introduction I've given you, you'll have a very fine semester. All the best, and see you again in another video. Bye.
Free audio post-production by alphonic.com.